Hi, my name is Vlad Genshu, and I'm a personal injury litigation and trial attorney here in California. I have tried 14 civil jury trials to verdict. Never been a second chair on any case. I first chair all my cases. I almost never have anybody co-counseling them. I want to talk to you today about what is an effective, or more importantly, ineffective cross-examination by the other side of your client on the witness stand look like. So let's just get right to it. The point of cross-examination is called the crucible of truth, right? The other side, or in your case, when you cross-examine, you're trying to get the truth. You're trying to hold the other side's witnesses to the fire to make sure you're trying to hold their feet to the fire to make sure that what they're saying is the truth, right? Anybody can be prepared on direct examination to say whatever needs to be said, right? The Melvin Belly had a famous quote about experts and what he thought about experts. So the entire concept that the direct examination is going to go well on either side, should be a given, right? You should never bring a case to trial if your case is going to fold and your experts or your clients, you don't have a case. Why even bring the case? You got to make sure that you have a right and meritorious case. And obviously, the direct examination is going to flow from that. So the next question is, okay, well, you put your client up, you put your experts up, but in this case, I want to talk about your client, the people that were in the car crash, or the people that you're actually representing, people in the car crash, slip, fall, trip, fall, dog bite, whatever kind of personal injury case it is. What is an ineffective cross-examination look like? Meaning, what has to happen or not happen for the defense attorney when they get up there? What is an ineffective cross-examination? Okay, what does a direct testimony have to look like? What does it have to be prepared like so that you have the other side when they come up there and they start asking questions of your client? Okay, what basically will a bad cross-examination from the other side look like? Which means that, in effect, the direct testimony is accurate, truthful, effective, and it's going to get what you need, what the client needs in order for truth to come out, to have that accurate and fair verdict. That's what verdict means, the truth. Just like voir dire means truth, to speak the truth, voir dire, French. So the idea is, remember, cross-examination is a test. You're testing. The other side is testing the theories of your case, right? Your client claims to be injured. Your client claims not to have caused the accident. Your client claims this. Your client claims that. The plaintiff claims that. So just to break it down really quickly, a very ineffective cross-examination means your client has told the truth, okay? And they don't have anything to attack them with. And it's going to be a short cross-examination, and they're going to say, I'll move on, okay, I'll move on. They won't be able to impeach with much in the deposition. They won't be able to do much. The real question is, how do you get there? Well, you get there by what Johnny Cochran would say in his book, Journey, or A Lawyer's Life. That's the book. He said, in A Lawyer's Life, he said, preparation is the key to a good trial. It's all about preparation. It's about preparation. People who are not lawyers, when they hear that, they think, oh, you're coaching. That's not true. That's not true at all. There's no coaching going on. This isn't a football game. All right, this isn't a basketball game. This isn't a hockey game. What needs to happen is you need to understand that the reason why an expert witness is ready on day one to go into court and give their, the facts as they see it, give their expert testimony, is they've done this hundreds of times or tens of times, 50 times, 100 times. They're not nervous, right? When you have a client and it is their life, it is a personal injury. Remember those two words, personal and injury. It's personal to their life, right? It is an injury. If you get injured in a car crash, if you get injured in anything, or if you even have a business dispute, if you have a real estate dispute, if somebody's trying to throw you out of your home in a landlord-tenant dispute, whatever it is, a divorce dispute, which is easier because you don't have a jury, but it's more on you because it's very, very personal. You are not going to go up there and testify in the same way as if it was attenuated, as if you're the expert who you're not feeling it on your skin, on your life, right? You're not going to lose your kids if you're an expert in a divorce case, if you're the forensic economist. You're not going to potentially not be compensated for a year of missed work if you are the economist in that case on behalf of the plaintiff or the defense. So of course somebody, and it's not just about education. Oh, well, a lot of plaintiffs, they might only have a high school degree or an associate's or maybe half a college degree or even just a college degree. It's not about that. You can bring an expert to the stand that is very experienced in what they are talking about. You can bring a car expert, a motorcycle expert who might only have a bachelor's, and they will testify with confidence, competence, and credibility because it is their domain field. If you've ever watched the news and you look at these experts about political aspects, or you watch CNBC or Fox News or MSNBC, you see these people, they're talking about the Middle East and all that. Usually those are not the people that are right there on the front line having, the bullets fly next to them, unless those are people in the military, right? So you're either dealing with professionals who are not right then and there, or people that are professional and they're handling it day in, day out. That's why those witnesses don't really need to be prepped. And that's why a lay witness, somebody that has experienced the trauma, somebody that is being sued or is doing the suing, it is actually their life. They need a different kind of treatment and prep. You don't need to spend much time with an expert. They know what's going on. A medical doctor knows what medical treatment's about, right? If they're the kind of doctor that comes and testifies on behalf of a medical doctor in a medical malpractice case, or a medical doctor or a patient suing a medical doctor, obviously that person knows a thing or two about medicine. They're a medical doctor in that subfield, right? They understand the standard of care. Your clients might not be blessed to have all of that knowledge and experience, but they are still human beings, and they have the right to be respected, treated with decency, met face to face, and told, hey, let me explain to you first, what is this process called the court system? What is this process called the jury system? My recommendation to any lawyer going into court, is try to get there a little bit early every day, at the very least, with your client. Maybe go there a day before or a week before court, before your trial, and show the plaintiff, your client, or the defendant, if it's your client, what does this courtroom look like? Where is your client going to sit, right? I have a feeling that many attorneys don't do that. And they don't do that because they're a little bit too professional. The excellent plaintiff's lawyers, the Nick Rowleys of this world, the Carl Douglas of this world, God rest his soul, the Johnny Cochrans of this world, they would do that. Nick Rowley goes into his client's home and he explains to him or her, what happens, how it happens, because you want to see how your client reacts when little Johnny or little Sally spills the milk. Are you going to yell at your kids, or are you going to say, no problem? Because that's going to show you the kind of stress they're going to be under. So a good prep for a tough cross-examination from the other side goes into understanding not just this, but this. And the only way you're going to do that, and I can tell you that as an attorney who's done that for a long time, is you're going to have to spend a lot of time with your client. You're going to have to spend a lot of time in their home. You're going to have to spend a lot of time with them. Not just reading the deposition, that's very critical, but asking them, how did this happen? What is your life story? Where are you from? Right? And if you have a language barrier, bring a member of their family who speaks the language that you also speak in order to communicate and convey this. That's how a good prep for a cross-examination starts. It starts with a very simple concept that a lot of people who wear suits forget, and that's the concept of trust. The client has to trust you. Every time I go to court, I almost never call them the client. I call them their entire name. John Smith, Miss Alvarez, Mr. Alvarez. Why? They're not my client. They are my client legally, but you need to understand that it is trial by human. And when you get that, when you understand that concept, when you've spent hours and hours and broken bread with the client, maybe they even made you the food they like in their home, as you go through the deposition, as you go through the medical records, and you show them what the actual courtroom looks like, right? And you show them what a deposition looks like before a deposition is taken. And you explain that. I'd argue to you that the wall of mistrust between the legal system and ordinary people begins to be broken down. And then it's easier and easier for people to fundamentally understand what questions will be asked Because if you just say, hey, don't worry about it, it's just an interview under oath, this, that, and everything else, that doesn't mean anything. Those are slogans. Those are bumper sticker slogans. You need to put in the time, not just phone it in. Don't just do a Zoom. Don't just do a Zoom call. Don't just phone it in. You phone it in. There's a reason why they call it, they're phoning it in. Meet them face to face. I go to CPK with them all the time. I pick up the tab. Why do I go to CPK? I like CPK. I also think it's good food. I sometimes meet the client in their home. Why do I do that? It's a safe space for them, right? If the deposition is going to be taken in their home through Zoom, why not meet them before in their home? Not just before the Zoom day, the Zoom depo day, but way before that. What does a good cross-examination look like? Meaning a weak one from the other side, a good prep for a cross-examination where your client's told all the truth and everything not but the truth. All the truth. What's that saying goes? Nothing but the truth, everything the truth, and so help you God. That's it. And when they get cross-examined, there is almost nothing that the defense can do. Because they're going to say, oh, I'll move on. They can't cross-examine. Your client shouldn't be arguing with the defense, of course. But they will, fundamentally, the defense attorney won't have much to cross-examine because your client has explained everything on direct examination. They feel confident with you on direct examination. And remember, we had a previous video about this on cross-examination. Your clients are the star on direct examination. On direct examination, your client will have explained everything. You ask a simple question. Ms. Alvarez, where are you from? Mr. Smith, where are you from? When did you come to Los Angeles? Where'd you go to school? Paragraph answers. Let the defense object. Let them ask you your next question. Paragraph answers. Don't lead your client to the answer. You can't have leading questions. Don't lead your client. The opponent, the cross-examiner, the defense attorney can lead. That's fine. You get your client's story, the facts out through short questions. They give you the long answers. An excellent cross-examination prep, meaning a weak cross-examination by the defense, begins and ends with you and the client. By the time the cross-examiner gets up there, he or she should realize they really don't have much to work with, which means that the client needs to know their full file. They need to know everything that's been subpoenaed. The defense attorney will send you. Let's say we're going to subpoena all the records from Cedars-Sinai, from Kaiser, from RadNet, right? From this school that they work for, from that school, from the place they used to, work here and there. You need to know what are in those records. You need to ask the client, listen, you tell me you've never had a neck injury. You said that in your deposition, or you told me that. You got to be careful. You got to be 100% careful because they're going to cross-examine you. So you better be sure that there was no neck injury. If not, we got a problem. So again, it starts from day one. You better take a righteous and just and true case. You meet your client and you say, how did this happen? You make a determination if this is a meritorious case and a meritorious client, and you work from there. You build the case from there. You don't want a case built on a foundation of sand. That's not a real case. You work on with that. And then you see, okay, this is where my client, this is how they got injured. This is how it happened. This is how the crash happened. The slip and fall happened. This is the injuries they've had. My client's 50, 55 years old, 45 years old. Of course, they must have had some other kind of neck or back injury. Has it been resolved? Did it, are they young? Did they ever go to the doctor before? When? You need to ask these questions. They make you think like a lawyer in law school, not just to answer questions on the bar exam, but because there is no A, B, C, D multiple choice of practicing law. You need to ask your questions the tough questions. Ask your clients the tough questions because the other side will. All right, whether it's in written discovery, in deposition, or in cross-examination at trial. And you cannot phone it in. You can't dial it in. Your client needs to know that you are there with them from day one in their house. You're there with them in the trenches. You've shown them the courtroom. You've shown them you need to practice a cross-examination on them. A tough cross-examination. Firm but fair. And that way, that client's going to know this lawyer means business. This lawyer is not going to pull any punches with me because I know that the opposing side was trying to minimize my losses, minimize my injuries, say it's my fault. They're not going to pull any punches with me. They're not going to pull any punches with me. That's what ultimately at the end of the day is zealous but ethical and effective advocacy. I wish you the best of luck in your next trial.